Could I see Chase Lopez? Hello. Hi. Thank you so much for dressing appropriately for court. Your client, your attorney is in court in a jury trial in county court at law number 14.
Okay.
She's asked to be reset. So you're gonna be, I'm sorry, June 10th. So you're gonna be reset for June 10th.
Yes, ma'am.
Once you sign the reset form, take a copy of that form to your attorney. She's in county court at law number 14. It's on the second floor.
Okay.
All right.
Where do I sign that at?
They're going to give you a copy of it right here.
Okay, thank you.
All right. You're welcome. Logan, who's here on Logan Denny? Oh, come forward. Who's the attorney on Logan Denny? Have you all conferred?
Yes.
All right.
Yeah.
Hello.
How are you?
I'm doing okay. How are you doing?
Thanks for letting me read more.
Yeah, all right. So counsel, where are we on this case?
Judge, I filed this morning. It hasn't been accepted yet, but I think it probably will. If it's not, I'll redo it, but there's motion there.
Norma, let them know that he's to have a competency evaluation, and I've signed the document. Logan Denny. So we're going to recall your case. And we're going to recall it for June. Norma, put this on June 16th. Yes. All right. All right, counsel, is there anything else?
No, Judge?
Have you received the discovery from the state?
Yes, Judge.
All right, thank you.
Thank you, Judge.
Do
Appreciate
you
it.
have any questions?
No, ma'am. So I'm rescheduled for June.
Yes, for June 16th. Your attorney has filed a motion to have you evaluated for competency. All right. Thank you. Teresa Frias? Yes.
Let me approach, Your Honor.
Yes.
Off docket matter. Since I was here on some other cases this morning, I just wanted to see if the court could entertain my request. It's set for next week, on the 13th. The system seemingly spit out a date. However, we had a vacation letter on file. I'm gonna be out that time frame. I wanted to see if it could be reset to May 22nd. I have other matters in this court on that date, and I also need a little bit of time to review some new cases, so allegations that they allegedly picked up.
All right. And is your client in custody?
Yes, Your Honor, she's in custody, and she was not set today, but I did inform her on our visit that I would be seeking to remove the date because I'll be unavailable.
All right. All right. We'll reset it for May 22nd.
Thank you, Your Honor.
You're welcome. Who's here on Erwin Ellison? Who's the attorney for Mr. Ellison? Come down. All right, counsel, have you received all discovery in this case?
Yes, Your Honor.
Who's the state on this?
Mr. Brown.
In this case, were you able to tender an offer?
Yes, Your Honor.
It is Erwin Ellison.
Yes.
All right, how old are you, sir?
31.
All right, Ms. Ferguson. I'll set this for June 16th. All right, be ready for trial. All right, thank you. Sign the acknowledgement of discovery before you leave, please. All right, Keith Hutt. All right, so here's my question. The criminal history that's listed in here, is this his criminal history?
Yes, Judge.
All right. All right, Mr. Hunt. I see that you filed a motion for early termination.
Yes, ma'am.
All right, I know that you've completed everything, but I look at everything in total, right? And part of my concerns are your prior criminal history, right? So I'm really not inclined to terminate you early. I know that the probation is recommending termination early. I know that you've completed everything. What I can do is I can allow you to report by mail.
Right now.
Yes. So they will give you cards and you just have to send them in. So you don't have to come in to do that.
Okay.
And then what I will do is with regards to UA, how often is he doing a UA?
Every month.
Every month?
Yes.
All right. Have there been any concerns with UAs?
Okay.
All right, then what I'll do is I'll change the UA to every 3 months.
Okay, Judge.
And then if you're doing well with that, then I'll consider changing it even farther out. But with your criminal history, I just don't feel comfortable with terminating you early. Okay?
Okay.
But, and then with regards to the fees, I'll waive the fees.
Okay. I think I already paid all my fees.
No, I mean, but he has a supervisory fee that would still be accruing. So I'm gonna waive those,
Okay.
okay?
All right.
But I hope you understand the reason why I don't feel comfortable doing an early termination.
I understand.
All right. And thank you for dressing appropriately for court. I really do appreciate that. And I want you to know that I believe that you have changed because you've completed this probation. I see the other history that you have were convictions. And so it doesn't appear that you were placed on probation for those, but on this probation, you did do everything that I've asked of you. So what I will do, because the state is opposed to your early termination as well, what I will do is you no longer have to report in person. And you can do the UA every 3 months instead of every month. And then I'll waive supervisory fees.
Those fees have already been paid in full, Judge, for the entire term.
Okay, all right, so you will have no more payments to make.
Okay.
Okay, and so it's just report by mail. Just remember to send the card in, okay?
Okay.
All right, any other
The
questions?
card, they're gonna send it to me and I send it back or?
Oh, yes, probation will explain that to you.
Okay. All right.
And let me ask you this, is it easier for him and for you all if he just turns it in or call in? What's the easiest thing?
Judge, it really depends on the unit, so it would go through his unit that he's in.
All right,
Have to go through the management.
do you have access to email?
Yes.
All right, because I want him to have proof of it in case something gets lost in the mail. I'll allow him to email once every 3 months.
Okay, Judge.
And that will count as your reporting, but you need to remember to email once every 3 months. 3 months, and don't destroy those emails.
Okay.
And Judge, there'll be other stipulations in regards to reporting by mail, but his community service, his officer will go through those with him as well as the manager.
All right, and if there's some issues of what they're asking you to do other than what I'm telling you, just come back to court and I'll take care of that.
All right.
All right, any questions about anything else? All right, thank you so much, and
Thank
thank you for completing everything. You're welcome. All right, Daniel Guerrero. All right, and state, were you able to tender an offer?
Yes, Your Honor.
Sir, how old are you?
I'm 47 years of age.
All right. All right, your plea deadline date is going to be May 27th. So at that time, you need to let the court, yes.
Your Honor, we've agreed to have a trial before the court, and Mr. Guerrero wants a trial as soon as possible. So,
All right, do you want a jury trial or a bench trial?
but he wants a bench trial.
Oh, bench trial?
Yes, Your Honor.
All right, so, and do you want the bench trial with me or do you want it with another judge?
Use fine, Your Honor.
Okay. All right, so I'm gonna tell you what I tell everybody else. If the state proves their case beyond a reasonable doubt, I'm gonna find you guilty. If they don't prove their case beyond a reasonable doubt, I'm gonna find you not guilty. All right. How long do y'all expect this to last?
It would only be about 2 witnesses or so, Judge, not that long.
All right, so if y'all will confer with the coordinator and find out when you all want it set, and then I'll set it for that day. Okay, Judge.
Thank you.
All right, thank you. Oh, and counsel, if you make sure, if I don't have it, the acknowledgement of discovery.
Oh, okay.
All right, and Mejia, on him, just a second, he needs to know when his next court date is. All right. Court is calling 2024 CR 009988 State versus Joshua Joseph Harris. Can I have parties announced for the record for the state? Defense,
Kelly Fiddle.
and are you Mr. Harris?
Sure.
Oh, I'm a ma'am. Or did you say yes, sir?
You said yes, Your Honor.
Oh, okay, I didn't hear that part. That's okay. All right. Are you all ready to proceed on this motion to revoke?
No, Judge.
All right, why is this being withdrawn?
Because the only violation allegations are new number ones that the state would prefer to have indicted and pursuing that matter.
All right. All right, any objections to the court reading the court summary?
No. There's not much in there, Judge. He's on probation for 4 days.
18, Your Honor.
All right, do you live with your parents?
Yes, Your Honor.
All right, I'm gonna alter and amend his conditions based upon my review of the court summary. Because it appears that probation has issues with you, you're contacting them, and sometimes you're answering your cell phone, sometimes you're not, then you're in the hospital shot and other things are going on. So I think your ability to move around freely needs to be curtailed a little bit.
ma'am.
So are you employed?
Yes, Your Honor.
What do you do?
Work at a wood shop.
At a wood shop?
Yeah, making cabinets.
Okay. What I'm gonna do is I'm gonna alter and amend conditions to include partial GPS for employment only.
Court
Now
waive fees.
ask that the fees be waived.
Thank you.
All right, is
For
there
how
any-
long, Judge?
until further notice? All right, is there anything else?
No.
All right, thank you.
Thank you.
Counsel, if you'll give this to the probation officer. All right, who's on Valerie Compean? All right, where's your client?
It's in custody.
Come down, please. Right, where are we on discovery?
Your Honor, I believe I have the discovery in these two cases. I haven't reviewed all of it yet. I was appointed on a few of them and she had another attorney, so they combined it.
Okay.
So I'm appointed on all of her cases. As you can see, she's got a lot of pre-file cases as well.
Well, yes, she does.
Yes. And so I'm asking, this is the first time I've been in court on this case.
Okay.
So we're asking for a pretrial reset, so that I can make sure I have discovery in all of the cases before we move forward. And then in addition, the pretrial cases have reached past the 90-day mark. I think we're on day 94, at this point. And to my understanding, the case, although the pre-file cases, they have already been assigned to the 187. So we're asking the court for PR bonds on those pre-file cases that remain unindicted past the 90-day mark.
State?
As far as the pre-file cases, assuming that what defense counsel said is correct, because I personally have not looked at those, and the state doesn't have much like to stand on in terms of protections.
All right, so if you review those, and then the court will take that matter up today.
Okay.
So I'll hear it today.
Okay.
So if you'll give them a chance to look into that, and then I'll take that
Yes,
matter
Your
up.
Honor. Thank you.
All right, you're welcome. Mike Hernandez?
Good morning, Your Honor.
Good morning.
Good morning, Judge.
Good morning. I'm doing great. Where's Mr. Hernandez?
I was coming up.
How's it going?
Not too bad.
Almost time for school to be out.
It is. Girls are excited.
Tell them, don't get too excited because the closer you get to graduating, the closer you have real responsibilities.
That's true. The real world waits.
Oh, yeah. All right, so has all the discovery been completed in this case?
It is not, Judge. I talked to defense counsel out in the hallway. My understanding is there have been attempts to put things into Verific that for whatever reason have not reached him. So what we decided is he's gonna give me an external hard drive. That way I can just download everything for him and then just go around the issue, the technological issue that we're having.
All right. So when are you gonna have the external hard drive for him?
When
We'll
can
get
you
it
bring
this week.
Oh,
Today,
okay.
tomorrow, but just the zip drive, right?
I would assume. I'll double check and make sure it's nothing voluminous that would eat up a lot of space, but I'll text you and let you know.
All right, I need a 30-day reset for discovery. All right, June 9th.
Very good.
All right, thank you. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Judge, I just need to know, is someone in the know, a very important question, were those crawfish things a real thing out there? You have some experience with those, right?
Yes.
Louisiana?
All right, let me just tell you, I'm a firm believer that leaving seafood on your plate should be a felony, right?
It's wrong.
My one exception to that, you know, with crawfish, how people just take the head off and they say that's the best part.
Mhm.
I don't do crawfish.
There's a lot of work for a little, that's what I
Yeah, it
know.
is. So I don't do that.
Alright. So did it qualify for the Louisiana standards?
Let me put us on mute.
Yeah.
But yeah, that's my honest opinion.
Mhm.
But I'm gonna give it another shot. All right, guys, have a good one.
See you next time, Judge.
Who is here on Luis Morales?
He's walking up here.
All right. Hello, thank you for dressing appropriately for court. We are batting 100 on people dressed appropriately for court. I love that. All right, so where are we on discovery?
We're still reviewing the discovery. There's a bunch of videos. I just need some time to continue reviewing that with my client. I've conferred with the state, let them know that I'm still reviewing it, and then after that, we can get an offer and then go from there.
All right, Ms. Ferguson, I need a discovery date. All right, it's gonna be June 9th. State, June 9th, you need to be prepared to tender an offer on Luis Morales. All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
Thank you.
Go ahead, I'll wait for me.
Kenneth DeLuz. Who's the attorney for Kenneth DeLuz? All right, on this case, where are we on discovery?
Your Honor, we're only set on the bond modification, right now. The 19th, on that date, that's when the actual case was set. We were set earlier this week, but
Okay.
I had to reset it for an actual hearing on the bond.
All right, now I understand. All right. He's asking to be allowed to work. Are you all in agreement or no?
Your Honor, I believe we did hear this and the court was just wanting proof of employment and defense counsel did provide that.
This was directly from the pretrial service officer as well.
Okay. All right, let me just explain. I'm a little bit confused by the document. Or maybe I'm interpreted incorrectly. All right, State, do you agree that the hours he works are from 9 a.m. to 8 p.m. Monday through Saturday?
I mean, I don't agree, Your Honor, because I don't know. My understanding was that was his personal business. Is that?
Is this your personal business? And what do you do?
Like think of Geek Squad.
I'm sorry, what?
Think Geek Squad. I'm a computer guy. I repair computers. So I have a PO box where I go pick up computers and I go to people's houses and I knock out computers, whether it's businesses or computers, and not to mention that I work for another company that does ATMs. So I do Rocket Credit, which is Bitcoin ATMs. So
I'm sorry, you need to speak up.
I also fix ATMs. So you think like, I'm not sure if you know about Bitcoin, but Bitcoin ATMs, that's what that is as well. So I have a contract with a company that does Bitcoin ATMs where I have to move. That's the reason why I'm asking.
All right,
to
so
be
what
able
I
to
can
move.
tell you is, one, I didn't know this was your own business. This 9 a.m. to 8 p.m. doesn't work for the court. I'll allow you, well, I mean, this is what I'm telling you. I'm not doing 9 a.m. to 8 p.m. and 10 a.m. to 8 p.m. I'm not doing it because the hours that you're posting, these are hours that you say, I don't have any proof that this is actually occurring. All I have is your word saying, I'm going to a PO box to pick up computers. And I do this from 9 a.m. to 8 p.m.
And I also look at houses.
Well, again, this is from 9 a.m. to 8 p.m. I don't have any proof of that. All I have is you're saying it. And I'm not going to agree to a time from 9 a.m. to 8 p.m. That's more than 8 hours a day.
Your Honor, an alternative, my client would be able to limit his hours to a traditional 9 to 6, 9 to 9, or I guess it would be 8 to 6, just to give him that window of being able to travel.
I'm not doing, I'm telling you, if I allow him to do this, it's going to be normal business hours. It would be 9 to 5. And even when I'm doing it 9 to 5, he needs to have documentation that he actually went to a PO box. The time he is going to that PO box, he needs to provide it to them.
I don't know how. Just going to the mailbox, I'm supposed to. This is the problem that happened with the GPS officer in the first place.
So here's the thing. This is what I'm telling you.
I'm not trying to be.
And no, I don't take it as being difficult. I understand that you want your hours to 9 to 8 p.m. The state is saying they don't want you to have it at all. I understand why the state is saying no, because you're on bond for continuous violence against family, violation of bond or protective order, assault and stalking. So here's the thing, whether it's true or not, I don't know. All I know is what your charges are. All I know is my job is to protect the community. All I know, at least one of them, all I know is your attorney is saying that you can't pay for this GPS because you're on full house arrest. So this is what I'm sorry.
I can't pay for anything right now. I'm about to be homeless.
Yeah.
This is why I need to work.
All right. I will tell you this.
I need to work Sundays too, and I need to, and if I'm
Well,
not.
that's not gonna happen. I would-
Your Honor, if we can ask that it be modified to the 9 to 5, my client will provide the necessary proof at this point. If that is the court's order, he will abide by the court's order. And I will make sure that he understands that that is the court's order at this. It is better than nothing at this point because he does need to get to work, Your Honor. He is going to be homeless soon if he cannot start making, money. He's made current arrangements with his landlord to allow him to stay there. But he is behind, I believe, a month or 2 months behind rent already.
I need to leave. He's already given me a termination on my lease, so I need to get out of there. So I gotta be able to generate something. And maybe I was asking for just tracking only so that I could move around.
No, tracking is not going to be allowed. That's not even a consideration.
Can I speak? I don't know.
You can speak, but I'm telling you.
No, I'm just gonna ask a question.
Sure.
I'm asking a question. So I was told the other day by the DA that I'm gonna listen to you. I'm not gonna talk.
No, I'm listening. Go ahead.
I'm not gonna talk.
No. Here's the thing. I will tell you, I keep an open mind. The issue that I have with you is that the timeframes he's asking for, there's too much of an open window. And basically, if I allow him to do this, it is sort of like tracking because he's saying he's working from 9 a.m. to 8 p.m.
Yes, sir.
I don't know if he's going to a PO box or whatever. Somebody would have to ask the pretrial services to do that.
I need to generate money.
Your Honor, if we can, I like I said before, we are willing, if the court is only allowing him to work from 9 to 5, my client will make the necessary arrangements for his business to be able to work within those hours that the court allows. We are asking that it be modified to allow that at least. He will just need to have to modify his hours at that point.
All right, so this is what I'm gonna do, and I want you all to write this up and state, I know you're not in agreement with it, but I'm gonna want this written up. So his hours that he's allowed to work are from 9 to 5. That includes going and coming. He is going to have to pick a specific time when he is going to be traveling to go to his PO box. And he needs to put down the location of the PO box. And in these hours from 9 to 5, Monday through Saturday, he needs to put in the order the time in that block of time that he is going to be traveling to his PO box. And if somebody calls him and they want a computer repaired, he needs to call pretrial services to let them know, I've received a phone call. This is the specific address that I'm going to either pick up a computer or repair a computer at this address. And he needs to tell them how long he's going to be at that address.
Speaking,
Yes.
I vote when pretrial don't answer because they never answer. I can't even speak to my pretrial officer. He
Send an
doesn't-
email.
Your
I
Honor,
have proof of all the emails I've sent to him.
Well,
Your Honor, if I may,
Mhm.
if I may, I understand the court's order. I know he needs to give documentation. I know he needs to tell them that he's gonna go. But sometimes, as he is saying, there is time constraints of when,
I'll just put it in an email.
And-
It's a paper trail.
of course, Your Honor, so he wouldn't need confirmation from them to say, yeah, you can go there. It would just need to provide documentation of proof. This is where I'm going.
This is what the court's order is. He needs to sit down with you. And for each Monday through Saturday, his time he's allowed out is from 9 to 5, and has to be work-related only.
Of course.
So for example, on Monday, if he says, I'm gonna go to my PO box at 10 a.m. and he needs to pick that date, not I'm going at 10 a.m., then I'm going at noon. No, just pick one block of time that he's going to his PO box. In the order, put, defendant is allowed to go to his PO box on Mondays at, if it hypothetically, it's 9 a.m.
Mhm.
At 9 a.m., the PO box is located at this physical address. He's only allowed to be there for no more than an hour to get whatever he needs from that PO box. Now, mind you, sometimes people are standing in line. It's something that the postmaster who's in charge of that location has to give it to you. That's fine if he goes beyond that point, but at least the GPS will show that he's at that location at his PO box.
Okay.
So he's only allowed to go to that PO box once a day, pick whatever time he wants to pick it. And then if he has somebody who calls him and says they need a computer repaired at their home, he needs to get that person's address, email or call GPS and said, I'm going to go repair this person's computer. This is the address. And when he goes to that address, when he gets ready to leave from that address, because the GPS should show I'm at 300 De La Rosa and I'm still here repairing a computer. When he gets ready to leave from repairing that computer, he needs to send them an email and said, I've completed repairing this computer, or I'm leaving this location, and then he goes back to his home.
Okay.
So if y'all can.
Can I stop and get something to eat?
No,
I can't
Just
stop
for
and get
work.
something to eat.
that's what Uber, don't they have Uber Eats or something else that happens? They
And who
have
can
delivery.
afford that when I can't work?
All right, let me just tell you, here's the problem, and I want you to internalize what I'm saying.
I am.
No, I mean, seriously, internalize it. I do not take any of these charges against anybody as true. I don't take it as beyond a reasonable doubt because I haven't seen any evidence. But my job in this part of the process is to make sure that the community is protected. Part of your problem is you're charged with continuous violence against a family member. You're charged with violation of a bond or protective order. And when you have a violation of bond or protective order and it's in felony court, that means that there are extenuating circumstances against that. That means that somebody allegedly has told you before, this is a protected class of people, you're not to be around them, and allegedly you violated. Then I have assault stalking.
They
So-
violated. I
so-
didn't violate them.
Here, then we have this assault stalking thing. So
Yes, Your Honor.
that person will be very concerned. And so do I consider the complainant? Yes. Because at the end of the day, the complainant, whether what they're saying is true or not true,
Sure.
they don't want to end up at some store and then all of a sudden they see you.
If I can give some context, just
Yes.
on my client's behalf, because I know he's wanted me to say it at this point.
Sure.
Is that the complainant has submitted two different, I believe, affidavits or statements to the DA's office where she has recanted her story, as well as the modification has been modified to no harmful or injurious contact.
Mhm.
So I believe my client, I think what he's trying to get at is, when we were talking about tracking, or when we're talking about the GPS, I think his position or our position is that there wouldn't be I guess, harm to the community because the complainant is on board with him working and getting to.
Well, let me ask you this. Have
She's
you
right,
received
she's
all
right
this-
outside.
Have you received all discover? Do you want to talk to her? She's right outside.
She's right outside. She's sitting right there.
The court knows sometimes the state has to step in to protect the community.
All right, so this is what we can do. We can set this for trial next week if you all want to trial. I'm here. You're here. The state's here. I can put it on
I
trial.
believe we're close to an agreement. We've been conferring on the matter
All
already.
right, well, I mean, if you all want, I'll call you back May 13th for a jury trial. You can either do a jury trial, bench trial.
I'm not
Let me
scared of
explain.
none of that. Nothing happened.
Now, what I am telling you is, and this is the problem, I don't know why you won't listen. That's part of your problem. You don't listen. Now,
don't even
what
know.
I'm telling you is, I will bring this back on May 13th. You can either have a bench trial or a jury trial. Will you be ready for jury trial on the 13th?
Your Honor, there is another,
There's another case, Your Honor, we are trying to, we're close to wrapping all of his cases up in a global offer. We would just ask that the court give us some time. to-
on May 19th, Your Honor, when we're coming back, on that day, we will have the answer whether
Right,
this
but-
is going to be a plea or a trial.
But what's the other trial?
Thursday, right, Your Honor.
All right, so then I have that to work with. So this is what we're gonna do. We're bringing back this on May 13th. There'll be your jury trial date. You can, the witness can come, not come, whatever is gonna happen. May 13th, jury trial.
Thank you, Your Honor.
All right, thanks. Ms. Ferguson, give them a date for jury trial, May 13th. Oh, it's gonna be a jury trial.